Good afternoon and welcome to the BRR Legal Brief, looking at the major legal issues affecting Australian business. I'm David Bushby and today we're talking social media, and in particular we're looking at the recent Advertising Standard Board's ruling in relation to the Smirnoff and the VB Facebook pages, which decided that those pages would be advertisements or subject to advertising standards, which include the posts of their third-party users. Here to discuss what this means for the social media industry and in particular business page owners is Samantha York from the Interactive Advertising Bureau. She's the Director of Regulator Affairs there. Thanks for joining us, Sam.
My pleasure, Dave.
And also Catherine Edgehill, who's a competition and trade practices lawyer at Truman Hoyle here in Sydney. Welcome, Catherine.
Thanks, Dave.
Sam, I just want to kick off with the VB and the Smirnoff decisions. What happened here?
Well, Dave, VB and Smirnoff, like many other brands around the world, created pages on Facebook to promote their products and services and their brand more broadly. One complaint was made to the Advertising Standards Bureau here about some of the third-party user-generated comments that were appearing on those pages, and the complaint was that those comments violated the Code of Ethics that the Australian Association of National Advertisers have developed and the Code of Conduct that the Alcoholic Beverages Committee have developed. And in this instance, the ASB found that the comments on the Smirnoff page actually were not offensive to broader community standards and didn't violate those codes, but that in the VB case there were some comments there that were offensive, did violate the codes and should have been removed by the advertiser. I should flag that the controversial perspective on this and this determination is that the ASB found the advertisers to be responsible for those comments, despite the fact that the advertiser didn't write them, didn't publish them, and didn't editorially select which comments to publish on the page. So they appeared there through the acts of third parties, yet the advertiser was held responsible for those.
Well, it's certainly got social media marketeers into a spin. There's a lot of frenzy over this decision, and it's as if for the very first time those pages or content of those pages means that the page owners would be liable. There seems to be two, I guess, issues here. One is the advertising overlay that we've just been talking about, and another one is liability for misleading and deceptive posts that appear on Facebook pages. Catherine, can you talk us through that?
Yes, certainly, Dave. There's nothing really new as far as the law goes with this recent decision. What it really is sending a message, though, I think, is that even though social networks might be considered fairly informal forums or places for conversation, they're subject to the law. From the misleading and deceptive conduct perspective, about a year ago, in February 2011, the Federal Court actually found Allergy Pathway and its director guilty of contempt of court arising out of some third-party posts on the Facebook account and a Twitter account. Now, those third-party posts were testimonials, and the court had previously found in the case of Allergy Pathways that certain things that it had said about its products were misleading and deceptive. They found that by allowing those testimonials to basically repeat that misleading and deceptive conduct, the party that was liable for them was the company and its director. And it was liable for them because it knew about that and it let it stay on its Facebook page.
And I guess sticking with the misleading deceptive conduct issue for the moment, we've seen one of the ACCC commissioners, Sarah Court, come out recently and state that at least for the larger players with Facebook pages, their expectation would be that illegal content on those pages needs to be taken down in 24 hours or even less. Again, is this a new standard or was this something expected?
Well, there's actually no standard in the Competition and Consumer Act, and I think what the ACCC is just saying here is this is our expectation, and from that perspective it's great to know what their expectation is. The real issue here, though, is if you're posting your own comments onto your own Facebook page and they're misleading and deceptive, you're not going to get that 24-hour takedown period. It's not like the Broadcasting Services Act that does actually have a takedown provision, a notice and takedown provision. But what it's signalling is a bit of leeway. It's the ACCC recognising that companies don't necessarily have somebody sitting monitoring their Facebook pages every minute of every day, and it's recognising that sometimes people post things at odd hours of the morning or whatever, so their view is 24 hours is enough time. And what it's really saying is you really have to be vigilant. The price of social media effectively is frequent and regular vigilance.
Absolutely. Sam, just to bring you in here again onto the advertising side, the Advertising Standards Bureau, I understand, is a self-regulatory body. It enforces the code of ethics on decency, etc. We had, of course, Smirnoff had a clean bill of health, VB not so lucky. So just talking penalties for now, what are the type of penalties are we talking about and who dishes them out?
Well, the ASB is absolutely an independent complaint handling body that manages complaints relating to the advertising codes, the self-regulatory codes. And in this instance, of course, Smirnoff were found to not contravene those codes, but VB did. The penalty that the ASB is able to deliver is to all intents and purposes, to uphold a complaint. And if they do choose to uphold a complaint, they can require the advertiser either removes completely or amends the content within the advertisement that was deemed to be in violation of the code. They also publish their findings, Dave, on their website, so there's a risk there for some negative publicity around an adverse finding, but they have no ability to fine advertisers.
Right, so no direct monetary consequences.
No, that's right, that's right.
Well, with these rulings, are they now set in stone? Can the rulings be appealed, for instance? Or could we even be looking at law reform here if the government are able to be convinced that this type of liability for page owners is excessive or too burdensome?
Well, advertisers have no right to appeal an ASB decision. Whether that's fair or not, I'm not here to say. If a complaint is dismissed, the complainant may appeal that decision and have that reviewed, but the advertiser upon whom an adverse finding can be made has no right to appeal. In this case, Dave, I mean, Catherine's mentioned a couple of pieces of legislation that impact on this space. The Broadcasting Services Act sets out what is really the global standard for social network operators, which is a notice and takedown standard, so that once a company receives notice that there's content on their site that's been posted by a third party that is illegal or which violates the terms of service for that site, the operator has an obligation then to promptly investigate that and take appropriate action, and that usually is to take the content down. And there are a number of tools that are available on all of the big social networking services that enable people to flag content for review and to report abuse. So there are good mechanisms in place. Where this decision by the ASB, I think, is a little inconsistent with those precedents is that they haven't required that notice be received by an advertiser before the need to investigate the content and take it down kicks in.
Well, I guess moving on to some hints and tips for the page owners out there, whether it's for Facebook or for Twitter. Catherine, maybe the first one to you. If a page owner sees a post on their site that is actually plain wrong, what are their options? What should they do?
Well, Dave, it really depends on how it's wrong. A simple thing that somebody puts a post that says, this product is wonderful and I like it because it comes in green and yellow and blue, but forgets to mention red. Well, that can be easily corrected. It can be a post from the owner which says, yeah, that's fabulous, and it comes in red too. But if it's a misleading and deceptive post, so if it's particularly something about the performance or characteristics of a product, for example, if somebody posts something like, your wonderful washing machines also iron my clothes, and they don't, then that's clearly misleading and deceptive. And if you leave it up there, you're going to be held liable for all the people who rely on that wonderful post and buy your washing machine and find out it doesn't iron your clothes. So in that instance, it's a takedown mechanism.
And Sam, I guess more of an advertising one for you. If we see something that is posted and it more falls in that indecent realm, it's not outright abusive, we'd hope that most people would take that sort of content down, but something that's treading that more of a finer line, what would you think?
Well, those boundaries aren't always very clear, are they, Dave? And it is a very subjective judgment call, because what's offensive to you may not be offensive to me, and vice versa. And one of my concerns about the potential for this ASB ruling is that it will force companies to very conservatively moderate content appearing on their social networking pages, just because they're frightened of that risk. And it may ruin the opportunity for online communities to engage in free expression of ideas and healthy debate, which is what a lot of these sites are really designed to engender, because people are frightened and they're risk managing, and they're employing very knee-jerk moderation policies to take anything down which might be remotely controversial, which I think would be a great shame.
Are you starting to get that feeling from members and feedback that you're getting?
Definitely, definitely, because people are concerned about this decision and the impact that it has on advertisers, and advertisers feel like they can't just wade into this halfway. They have to make a full commitment to moderating these pages now, and to avoid that risk of somebody perhaps being offended by something and making a complaint. Inevitably, moderation policies will become a lot more conservative.
Well, just to wrap up, I want to talk about, maybe it's a risk mitigation measure, but some companies are starting to employ terms of service on their actual Facebook pages, so rules about using their Facebook page. Does that add any value here?
Terms of use, those things that people often can't find and usually don't read. They are of value, Dave. They're of value in some ways as a preventative measure, because they're warning people that content will be taken down which is in breach of the law or violates policies or prevailing community standards or whatever. The real value of them, I think, is that they're a reminder that there is a legal context to social media, and there are legal consequences about what goes on to social media. And I think there has been a little bit of a disconnect between the two for a while. People have thought of them as just informal forums for conversations, when I think these decisions are starting to say, no, they really are a little bit more, and you have to be mindful of the laws that apply.
Absolutely.
I think the question just comes down to who is responsible, though, at the end of the day, Dave. Should it be the advertiser who's created the forum for people to exchange their ideas, or should it be the individuals who are publishing the offensive or illegal content themselves? And these terms of use do exist today on every site, and they are enforced on receipt of notices, but there's a risk too that if advertisers create their own versions of terms of use to sit on top of the platform provider's terms of use, there may be conflicts, inconsistencies, which one overrides the other. It leads to a lot of interesting questions,
Absolutely.
I think.
Well, it is very early days as we all learn to grapple with this technology and the pace in which it changes. But thank you again so much for your insights today.
Pleasure.
Thanks, Dave.
And viewers, thank you for tuning in. We look forward to having you join us for next week's BRR Legal Brief.